and welcome back to the Worcester Senior Center Stay Connected programming on Channel 192. My name is Suki Lapin, and I am the program coordinator at the Worcester Senior Center. Wise constitutional law instructor John S. Ross III and Honorable Martha P. Grace, retired Chief Justice of the Massachusetts Juvenile Court, return to the Worcester Senior Center Distinguished Speaker Series in collaboration with the Worcester JCC to discuss landmark decisions of the Supreme Court. Jack and Martha will focus on 4 historic cases involving the First Amendment, presidential power, and racial segregation of public schools, the separate but equal doctrine. Jack and Martha will explain the legal significance, historic context, and continuing impact of these decisions. I am honored to introduce Honorable Martha P. Grace, who was appointed as Chief Justice of the Massachusetts Juvenile Court in February 1998, retiring from the Massachusetts Trial Court in 2009. Prior to that, she had been Associate Justice of the Worcester Juvenile Court since 1990. She received a bachelor's degree from Smith College, a master's degree from Clark University, and Juris Doctor from New England Law School. In 2011, Judge Grace received a Master of Science degree from Tufts Cummings School of Veterinary Medicine's Animals and Public Policy program, and currently teaches animal law at the Tufts Vet School in Grafton, Mass. Now, please welcome Nancy Greenberg, Cultural Arts Director at the Worcester JCC.
Thank you, Suki. It is my pleasure to introduce Jack Ross. John S. Ross III, known as Jack, earned his undergraduate degree from Yale University and his JD from the University of Virginia School of Law, and a degree in taxation from NYU School of Law. He practiced law for many years in Washington, D.C. Jack has taught numerous classes in the WISE program, Worcester Institute for Senior Education, focusing on constitutional law and the Supreme Court. He also facilitates the WISE Supreme Court Special Interest Group. Please welcome Martha Grace and Jack Ross.
Today, we are going to discuss some selected landmark decisions of the Supreme Court. So what do we mean by landmark decisions? A landmark decision often establishes a new precedent that marks a significant new legal principle or constitutional provision, making a change in that interpretation. In addition, today we will probably see the historical or sociological context that are also important in these decisions. Can a landmark decision be overturned? Yes, theoretically, but it happens infrequently. Although lately we've been hearing a lot about whether a case like Roe v. Wade could be overturned, but that we're getting ahead of ourselves. The most significant landmark cases are those that have had a lasting impression and effect on the application of a certain law or constitutional provision, particularly if they involve individual rights and liberties. Jack and I are going to discuss 4 cases today, and I thank you for having us back. The first case is Brandenburg v. Ohio in 1969. It was a First Amendment case in which the United States Supreme Court held that the government cannot punish inflammatory speech unless that speech is, quote, directed to inciting or producing imminent lawless action, end of quote. The facts in this case are that a Ku Klux Klan member named Clarence Brandenburg invited a television reporter to cover a Ku Klux Klan rally. Portions of the rally were filmed. It showed men in hoods and robes. They were carrying firearms. They were burning a cross, and they were making speeches with references to persons of color and Jews in hateful rhetoric. He was charged with advocating violence for his participation in that rally under the criminal syndicate statute. he was convicted and sentenced to prison. After an Ohio Court of Appeals dismissed his claim that his First Amendment rights to freedom of speech were violated, the United States Supreme Court reversed Brandenburg's conviction. The court said, while the activities were protected speech under the First Amendment, because there was no imminent threat of violence. So Jack, the question for you is that the Brandenburg case is understood as establishing a new test under the Free Speech Clause, the incitement test. Can you explain what that means and how this test departs from earlier cases, for instance, Schenck versus the United States?
Thanks, Martha. It may not have entirely created a new test, but it certainly refined the test that the Supreme Court had previously adopted in several cases that actually dated back to World War I. One of those was the Schenck case that you mentioned, and that case involved members of the Socialist Party who were trying to obstruct the draft. The government, of course, saw this as possibly undermining the U.S. war effort and cracked down on them and charged them with crimes. In that case, Oliver Wendell Holmes wrote a famous opinion. It's the opinion that contains the phrase we often hear that you can't, yell fire in a crowded theater, unless, of course, there is a fire. And he essentially established what was often referred to as the so-called clear and present danger test. Okay, the idea that speech is generally protected unless it creates some clear and present danger. So moving ahead, there were a number of other decisions over the years, and then we get to Brandenburg, different set of facts, obviously. And in Brandenburg, the court really, as you said, developed what is now referred to as sort of the imminent threat of violence test. They said that the government can punish any kind of political advocacy only if the speech is directed to inciting or producing imminent unlawful action and is likely to achieve that. So that's the standard that we're still working with today, that was essentially set forth in Brandenburg. One of the important things to note about the Brandenburg decision is the court made it very clear that a so-called abstract support of violence is still protected speech. In other words, somebody's free to go out and say, I think that, maybe we should, put together a militia and take down the oppressive federal government. Well, if all they're doing is saying that without anything more to create an imminent threat of that happening, they're probably not going to be able to be prosecuted under the Brandenburg test. So that's kind of where we stand now.
Okay, in the past 50 years since Brandenburg, the court has had many occasions to revisit the issue of protected speech. Are there any trends that you see, and do their decisions always reflect what's going on in society at the time?
The court has really not backed away from Brandenburg. Okay, it has dealt with a number of freedom of expression controversies over the years, and some of them were in contexts such as the Vietnam War. In general, the court has been very willing to protect even very offensive speech, things like hate speech, for example, cross burning, flag burning, that doesn't directly, imminently, create a threat of violence. This all goes back to one of the core principles that underlie the First Amendment, that the idea that we need to have this so-called marketplace of ideas in our society. And as hateful or undesirable and offensive as some speech might be, it's important that people be able to express those thoughts. So, the trend has generally been to protect speech, up until a point like, inciting violence. And it's a tough line to draw.
So what's on everybody's mind, and something we could probably discuss this entire time. However, I'm going to ask you to concisely tell us what you think about the role of social media. What responsibility, if any, do platforms like Facebook and Twitter have to the public?
Sure. Yeah, this is a huge issue now, obviously, and there's a lot of talk about putting limitations on social media companies. Congress is looking at this. There's the issue of the so-called Section 230, which provides liability protection for social media platforms. What a lot of people don't understand is that all of these social media companies like Facebook and Twitter are private entities, and therefore they're not subject to the First Amendment. The First Amendment protects against government incursions on speech, not private incursions on speech. So as a result, these companies have been free to develop their own rules over the years, and they have done that, and they have put restrictions in cases like hate speech and speech that might tend to incite violence. And they've done this sort of on their own, and that's why it's controversial, because people question, well, how come these companies have the right to do this and make the rules?
Well, I'm sure in the coming months and years, we're going to be hearing a lot more about social media, but we're going to move on to the next.
Let me make one quick comment, Martha. Sure. The other thing that has followed in the wake of cases like Brandenburg and the incitement test are some of the violence that's occurred on university campuses, like in Charlottesville a few years ago, where you had alt-right groups assembling and counter protesters assembling, and it actually led to a tragic death. And that's a really tough situation for public universities when it comes to trying to curb any kind of speech, because they really do have to pretty much give a platform to almost anyone. So I just wanted to note that this is going to be a continuing issue that they're trying to struggle with. It's even divided the ACLU, to be honest with you, because they generally the ACLU usually steps in and protects these, alt-right speakers on the principles that the ACLU defends. But even within the ACLU, there's some controversy about some of this. So I just wanted to throw that out.
And that's a good point. I think the ACLU protected Skokie, Illinois.
They did. At
that time. Our second landmark case is Youngstown Sheet and Tube Company versus Sawyer. It was 1952. It's considered a landmark case because it limited the power of the President of the United States to seize private property. This case acted as a check on the most far-reaching claims of executive power at that time. The facts are that in the middle of the Korean War, the United States Steel Workers of America threatened to strike for higher wages against the major steel producers of the United States. Harry Truman, the president at the time, feared that a strike of any length would cause such severe disruption for defense contractors during the war when he needed them. So he issued an executive order empowering the Secretary of Commerce to seize control of the steel production facilities and continue production. The steel company sued on the grounds that the president had no authority to seize private property without express authorization from Congress. And the Supreme Court upheld a lower court injunction prohibiting the seizure of the steel mills. Jack, the Youngstown case is significant because it involves the novel question of separation of powers, the power of the president versus the power of Congress. How did the Supreme Court in this case resolve the issue?
So let's step back just quickly, because you're right, Martha. I mean, this is one of the classic so-called separation of power cases. And it's an intriguing case because it really does present one of those controversies between two branches of government that there really isn't a clear answer to oftentimes. So generally, when the framers set up the Constitution, one of the remarkable concepts they came up with was this idea of separation of powers, three branches of government, checks and balances. The Constitution, in some cases, is very specific in outlining the powers of the different branches of government. But in this case, you know, you had a situation during wartime where normally the president is going to be given a fair amount of discretion, right, to protect national security, right? That's what courts have generally done. But in this case, what we saw was the court basically said, no, President Truman has exceeded the scope of his presidential power. Why? Well, it's not totally clear, because part of the problem is there's so many different opinions in the Youngstown case, right? And almost every justice wrote an opinion, and they're all a little bit different, okay? What we do know is that essentially, and if you read the majority opinion, I think it was Hugo Black, basically said, when the president acts, he has to base his action either on some provision of the Constitution or on some statute, some law that Congress has passed. And if he doesn't, we're in a murky area. And in Youngstown, the majority of the court felt that Truman's action in seizing the steel mills went beyond any explicit powers that were granted to him, either in the Constitution or any federal statute. In fact, there were some justices that felt that some of the labor relations acts that had been passed, like the Taft-Hartley Act, may have even undercut his ability to act, that he might have had other options than doing what he did. So that's kind of the lesson, the general lesson that comes out of Youngstown.
Are there any more modern examples where the executive branch tried to assert its power without approval of Congress?
It's interesting. The border wall controversy that erupted, I think, a couple of years ago and is still ongoing in the courts was a situation where people were raising the Youngstown principle. But it's a little different. It's a little different situation for a couple reasons. One of which is that President Trump based his decision to essentially divert funds towards the border wall under a federal emergency powers statute that was enacted, I think, back in the 1970s. Now, there's a couple questions about whether his actions really were supported by that statute. But the fact is, there was a statute there that he could sort of, you know, rest his authority on, unlike in Youngstown when there wasn't anything like that. But the other problem, which gets more to the Youngstown issue, is that Trump essentially counteracted what Congress had refused to do. Congress had specifically refused to allocate funding for the wall, and Trump went around Congress by using the Emergency Powers Act. So in that sense, it does present an issue similar to Youngstown. And it's still, I believe that it finally worked its way onto the Supreme Court docket, but I haven't heard anything about it, about the status of that case lately.
It will be a while before we hear anything. It's always interesting that what many people don't realize is that the Supreme Court decides its cases based on the facts of that whatever particular situation they have in front of them. They need to go with those facts and only those facts.
There was one more. Let me just quickly mention. I mentioned there were a number of opinions in the Youngstown case. One of the ones that's often referred to as a concurring opinion by Justice Robert Jackson. And he laid out sort of an analytical framework for evaluating sort of presidential power and the separation of powers limitations. And what Jackson said was, there are three situations that you might encounter, okay? The first is where the president has the most authority is where Congress is either expressly or implicitly given him authority, okay? The middle zone, the so-called twilight zone, is where Congress has essentially said nothing, okay? And then the third case is where a president's action may conflict with congressional action or intent. Jackson saw the Youngstown scenario as the latter case. He viewed it as Truman's action as sort of inconsistent with the framework Congress had set up for labor relations. So I just wanted to throw that out. You'll hear a lot of references to his concurring opinion.
Well, what's sure is that this is an issue that's not going away. The challenge of the president versus Congress as authority is going to be ongoing. Okay, we're going to move to our next case, which is another First Amendment case, but in a very different context. In 1971, it was the case of the New York Times Company versus the United States. This landmark case involves the freedom of the press, in which involved the publication of the so-called Pentagon Papers during the Vietnam War. The facts are complicated, so I'm going to do my best. In 1967, at the height of the conflict in Vietnam, the then Secretary of Defense, Robert McNamara, commissioned a top secret history of the United States' role in Indochina, dating back to the 1950s. Now, Indochina then composed of Cambodia, Laos, Thailand, Vietnam, and Myanmar. Daniel Ellsberg was a government contractor who had helped produce the report. And he leaked 43 volumes of the 47-volume, 7,000-page report to a reporter from the New York Times in March 1971. The New York Times began publishing the articles outlining the findings in the report. The problem was the Pentagon Papers suggested that the administration of Lyndon Johnson had distorted the nature of the conflict and the chances for United States victory. The government obtained an injunction preventing the Times from publishing more of the Pentagon Papers. The US government claimed the publication of these papers, this report, would cause irreparable injury to the defense interests of the United States. It also argued the publication of the papers violated the Espionage Act. So they were objecting on serious grounds. A little bit later, the Washington Post also obtained portions of the report and began publishing their stories. The government sued again for an injunction. The United States Courts of Appeals in New York and Washington differed on whether the right to publish under the First Amendment overrode the government's interest in protecting sensitive information that might impact the war effort. So the newspaper's right to publish versus the government's right in protecting their own interests. Because you had two different courts of appeals deciding in two different ways, the Supreme Court decided to hear the case. The case involved the issue of what's called prior restraint. That is, did the government have the power to block the publication of the Pentagon Papers stories? After hearing the case on an expedited basis, meaning much faster than usual because it was so important, the Supreme Court, by a 6-3 decision, upheld the right of the newspapers to publish the material. Although the decision was a victory for the newspapers, it divided the court, and it did give the press unlimited freedom to publish classified documents, meaning that the issue could come up again. So, Jack, what did the court say about prior restraint, and why did it rule for the newspapers, do you think?
Thanks, Martha. Yeah, that was a good summary. It is a complicated background. I love the movie The Post because it lays out the whole story of the Pentagon Papers case. Really, I think it was pretty well done. So, the funny thing is, you say, well, what did the court say about prior restraint? Well, this is a little bit of an unusual decision that it's a per curiam majority opinion, which means that it wasn't really signed by any one justice, but 6 justices signed on for the result. And it's pretty short, but then there were a lot of concurring and dissenting opinions, kind of like in Youngstown, right? This could be a frustrating thing for those of us who spend time, reading Supreme Court decisions and teaching about the court. And, you like to think that there are some clear principles laid out and bright line rules. But, as you know, Martha, because, we've talked about this in the past, sometimes that's not always the case, right? Sometimes they reach a decision, but it's not always clear what the real, if there's any one real overriding rationale or reason for that decision. And this is a case that's a little bit like that. Now, in prior decisions before New York Times, the court had talked a lot about prior restraint, okay? And the prior restraint, issue goes all the way back to England, okay? The British government doing all kinds of things to suppress speech and the right of newspapers to publish anything that might have been, contrary to the crown and that type of thing. So when they put together the Constitution in Philadelphia in 1787, and they got to the First Amendment, one of the things they were really concerned about was this whole idea of preventing prior restraint, having a free press. So we do know that. And in this case, what you get out of the majority opinion here essentially is that the government bears a very heavy burden if it tries to exercise any kind of prior restraint on the press to prevent publication of material. It doesn't mean that in some cases they might not be able to do it, but it's a really tough standard for the government to meet. And in fact, the majority opinion basically said there's a presumption against allowing any kind of prior restraint. So that's important to know that the court views this extremely seriously, and they're not likely, absent really exigent circumstances, to allow any kind of prior restraint, and they did not in this case, even though, the government obviously had some equities on its side, with the fact that, all this sensitive information could undermine the war effort, and that type of thing. One of the ironies is that once that information was out, it kind of reduces the argument for prior restraint. I mean, once it's out in the public, the damage has kind of been done. But so anyway, that was sort of the main rationale that comes out of this decision. There were a couple justices that would have gone further and said, basically, no situation should the government ever be able to exercise prior restraint. But that was just a couple justices that felt that way.
Okay. So for those of our viewers who are old enough to remember what was going on during the Vietnam War, we remember the protests and the political instability. This case was particularly controversial at the time because the public was deeply divided over whether the United States belonged in the Vietnam War at all. So, Jack, did the attitude of society at the time have an impact on the Times' decision or desire to publish the papers and the government's desire to prevent the public release of the material?
Well, I think the newspapers certainly were intent on trying to uncover any kind of information that was there that was contrary to the public statements that the administration had made about the war in general. And they viewed that as an extremely important mission to sort of get to the truth. And if the government was hiding things and saying one thing in public and having this 7,000 page report on the other hand, that's something that any newspaper probably wants to break that story. But sure, the whole, you can't look at the case outside of the context, right? And like you say, Martha, facts are always important, and anytime, we think of factual development as often something that's more important maybe at the trial level, right? That's what you did as a judge, right? We often think that by the time a case reaches the Supreme Court, that, you're arguing these esoteric constitutional principles and the facts are just already been decided and they don't matter. But that's not true. The facts always matter. The facts always matter to courts and can influence the results. So the other thing is, getting to that issue is that, it's interesting. Douglas, William Douglas, in his concurring opinion, made a couple points. He said, first of all, he said the purpose of the First Amendment was to prohibit government suppression of embarrassing information. I mean, that was one of the things they wanted to prevent. And second, he said, the Pentagon Papers were relevant to the public debate over the Vietnam War, right? And secrecy in government is fundamentally undemocratic. He said we need open debate and discourse on these matters. So, sure, absolutely. It was a highly charged time.
It was. So since the paper's decision, the Pentagon decision, has the court clarified the test it applies in a prior restraint context, or the same kinds of facts to be presented before the court?
I don't think it really has, to be honest with you. I mean, I think when you're in this area, if a situation comes up, and they don't come up that often, but this is still what people look to for guidance, I think. It's not even clear, to be honest with you. The court, not to get too nuanced, but we talk about this in some of my classes, Martha, and the Supreme Court group we have in the WISE program. It's important for people to understand that when courts evaluate constitutional rights and things like that, they have different ways of looking at a case. In other words, they have what they call different kind of standards of review. What that means is that when you're dealing with a really fundamental constitutional right that the government action may impinge upon somehow, that often the court is going to apply a much higher standard of review, which is what they did in this case. Whereas in some kinds of governmental action, like regulatory action and things like that, it's a lower standard of review. The question I think that scholars have grappled with, I think, after the Pentagon Papers case, is it's not even clear that the court didn't even really specifically say exactly what standard applies, but they did say that it's a really difficult standard for the government to meet, a high burden to ever have prior restraint. There was one case after this that involved a former CIA employee who published a book, I think. And the issue there was the publication of the book and the publication of information that he had gathered during the course of his employment with the CIA. Did that violate his contractual obligations that he had made when he entered into government service, not to publish certain information? So that was a little different situation. And in that case, I think they reached a different outcome on that kind of contractual theory.
Just as an aside, do people in administrations, are they required to sign contracts saying that they will not publish after they leave for a certain period of time?
I think they almost always have some kind of non-disclosure kind of agreement, that lays out what they can and can't do. That was an issue with John Bolton, who was Trump's national security advisor. He eventually wrote a book. That issue had come up because they were trying to suppress his book, and they were arguing that he was publishing classified information. And he said, no, I've already run it by the administration. I went through the review process and they looked at it and they said it's okay. But then when the impeachment proceedings came along and more was at stake, then they said, no, you can't publish this. But he did publish it. So, yeah.
Okay, well, our fourth and our last case is the Brown v. Board of Education. At the time it was decided in 1954, the country had been living with the results of a case decided 60 years earlier called Plessy versus Ferguson. In the earlier decision in 1896, the court upheld the constitutionality of racial segregation laws for public facilities, as long as the segregated facilities were equal in nature and quality. Plessy v. Ferguson then stood for the principle that separate but equal was okay. That opinion suggested that segregation caused no harm and promoted public peace and good order. Though the Plessy Ferguson was controversial, even to some extent at the time, the country had to wait 60 years before an NAACP lawyer named Thurgood Marshall, who subsequently came on the United States Supreme Court, convinced the court in Brown v. Board of Education that the separate but equal doctrine was unconstitutional as applied in the context of public schools. Brown v. Board of Education involved a Black resident of Topeka, Kansas, Oliver Brown, whose daughter had been denied access to the school closest to her home. Brown joined 12 other local Black families in similar situations and filed a class action suit. The United States District Court based its ruling on the Plessy v. Ferguson ruling and ruled that racial segregation did not, in and of itself, violate the 14th Amendment, as long as the facilities were otherwise equal. Brown, the plaintiff, appealed to the Supreme Court. Chief Justice Earl Warren, in the Brown v. Board of Education, announced that separate educational facilities are inherently unequal, and therefore they violate the equal protection of the 14th Amendment of the US Constitution. Now, it was interesting because Earl Warren was appointed originally by Dwight Eisenhower, thought to be a conservative justice, and he turned out to be a lot more liberal. But this decision opened the doors to integration in other areas and was considered a victory for this now growing civil rights movement. So, Jack, what factors led the court in Brown to overrule its earlier decision in Plessy v. Ferguson?
Well, it's a saga. It was a saga, right, over many decades. It's interesting, Martha. If you go back and look at the Plessy v. Ferguson decision, there was a very, very strong, dissenting opinion by Justice John Harlan in Plessy. And if you look at that, the majority opinion that Earl Warren wrote in Brown v. Board of Education really echoes a lot of what Harlan wrote in his dissenting opinion in Plessy, which is interesting, 60 or so years earlier. We talk about this sometimes, right? That sometimes a very influential dissenting opinion can lay the groundwork for a change in the law, and that position can become the majority opinion. And that's sort of what happened in this case. But it took a while for that to happen. And part of what was happening in the intervening decades was that the NAACP Legal Defense Fund, which was really the pivotal person there, of course, was Thurgood Marshall, right? Later Supreme Court Justice, but at that time out on the front lines, arguing a lot of these cases in the courts, had undertaken a really broad assault on the so-called Jim Crow laws in the South, right? And there were many of them in many contexts, but the ones that, of course, became the focus of the Brown case were the school cases, the segregated public schools. But Plessy, as you may recall, involves segregated public transportation, right? Same idea, just sort of a different context. So we get to the Supreme Court, and there were a lot of decisions prior to Brown that had started to chip away at some of these laws, some of these Jim Crow laws, right? The problem was, initially, when this case comes up to the Supreme Court, you've got a divided Supreme Court. And it was really split. And then what happened was, I think it was Justice Vinson died, okay, and Eisenhower appointed Earl Warren as Chief Justice of the court. suddenly you have a new Chief Justice who thought a little differently about a lot of things. This is a person coming from a background of government, right? He was the governor of California, right? And he had a little different perspective on all these things. I don't think Warren ever, saw himself as a revolutionary of any type, but he was said to be driven by a simple sense of justice, basic values. He was results oriented, pragmatic. He believed in justice and fairness, and he believed in an equitable view of the Constitution and the role of judges. So he brought all these things to the court. And the story is that when they re-argued Brown, it was argued more than once, okay? And that's unusual. Normally there's just one oral argument for a case, but they had argued it. There were divisions on the court. Justice Reed died, so they re-argued the case. And the story goes, and this is true, that it was very important to Chief Justice Warren to produce a unanimous opinion. He thought it was very important that the court speak, with a unanimous voice on this issue. And finally, I think it was Justice Stanley Reed was kind of the holdout, and I think Warren just put pressure on him, and he came along. But at any rate, it's one of the great examples of how Chief Justices can have some influence on what the court does. We look at, I know I'm going a little off track here, and I'll get back to Brown, but I mean, there's a lot of talk about the role of Chief Justice John Roberts these days. Has his power been undercut a little bit by the addition of Amy Coney Barrett on the court? Because now it's a much more conservative court. And whereas Roberts was sort of in a swing vote kind of position on a lot of issues, he doesn't have the same status on the court now to hold those coalitions together. So, this all goes to Supreme Court dynamics and how the justices relate to one another and that type of thing. But at any rate, finally, they came out with a majority opinion in Brown v. Board of Education that Earl Warren wrote, and basically said this doctrine of separate but equal has no place in public education. And he said segregated schools are inherently unequal. Okay. Whereas in Plessy, the court had said, well, you know what, everything's fine. This is kind of the world that we have. We all kind of coexist. And as long as they have kind of so-called equal facilities or whatever, we shouldn't really worry about this. But Warren's saying that just doesn't work, and that's what Thurgood Marshall had been arguing for years, that segregated public schools are not equal. They're not going to have equal resources. The students are not going to have equal opportunities. So at any rate, that was sort of the gist of the opinion.
Okay, so we have presented Brown v. Board of Education as a landmark case ending racial segregation in schools. Did it ultimately have that effect? What's happened since?
So Martha, I think there's a couple ways to look at this. And I think ultimately the answer is no, it has not had the impact that people had hoped, for a couple of reasons, for more than a couple of reasons. But going back to Brown, this is an interesting lesson, I think, about the power of the federal courts. The court can issue a decision, but the Supreme Court justices aren't going to get on a bus and go down to, Arkansas or whatever state it is and get the Black students together and drop them off at the white school, right? I mean, how is a court decision implemented? And what happened here initially was that they realized pretty quickly there was a lot more to do to, implement the goal of the initial Brown decision that, segregated schools are unconstitutional. So that they actually followed it up with a second decision, which was called Brown 2. And that's where the famous phrase, all deliberate speed, comes out of that opinion, that the court directed the school districts and the federal district courts in all of these states to move ahead towards achieving desegregation with all deliberate speed. Well, there were still school districts in the South that were not cooperating, right? So what are you going to do? You're going to bring the troops in? Well, that's what Eisenhower did, right? In Little Rock.
Yes.
He brought federal troops in. So that is a great example of, Felix Frankfurter, okay, going back before Brown, had always said, the courts can't do this. We just can't achieve these things. These are local political problems that are beyond the power of the federal courts. Well, you know what? When you have the president who's willing to back up the Supreme Court and send in troops, that sent a message that the federal government was fully behind that. So to answer your question, it took more than Earl Warren getting 8 other justices on the Supreme Court to issue an opinion to really have an impact. But to your larger question, where do we stand today? If you read a lot about, what's happening in a lot of school districts in certain urban areas, the progress hasn't been made that people had hoped. There's
Right.
still a lot of there's still a lot of segregation in a lot of schools. Part of that is because of geographic realities, right? But again, and it's beyond the scope of talking about Brown, but there are numerous federal court decisions where they've gone in to try to make changes with school districts, and the school districts have argued, well, you know what, this is just the natural state of the affairs because of this is the natural geographic dispersity of an area, and you shouldn't really have to change that. The problem with those arguments is that the reason some of these cities are so racially geographically segregated goes back many years to things like redlining policies, right, of the federal government, with not giving minorities loans and things. So, it's not that simple just to say, well, if we have these segregated communities, that's okay, because you have to look at why the communities are segregated to begin with.
Well, so it's 65 years since Brown. And many people would say, well, we haven't achieved substantial desegregation because of what you mentioned. It's de facto segregation in the neighborhoods you talk about, where the majority of the community is of color, and therefore the student body is of color. The Brown v. Board of Education case would say, well, you haven't achieved desegregation, but that's not affirmative segregation if that's where the people live.
Yeah.
So do you think the principle of Brown is still controversial, and could we do more to achieve Earl Warren's vision?
Well, as you'll recall, and I saw some of the impacts of this. I grew up in southwestern Virginia, and you remember the busing problems in many cities, and nobody liked busing, right? Even though the goal was laudable, right, to achieve more integrated schools, nobody really liked busing very much, and those battles were fought for years. So the question is, how do you get there? And I'm not sure anybody's come up with any really good answers.
So now we have a conservative court, more conservative than we've had in a long time. Is a precedent like Brown v. Board of Education in any danger of being overturned or maybe whittled away? And if so, what would small changes look like?
I think that when you look at Brown, I think the principle of Brown that, segregated schools, if they've been segregated by clear policies, in cities. I think that principle is unlikely to be overruled per se. I think the battlegrounds are more in the areas like, what are the possible remedies for various types of discriminatory, governmental actions. For example, if you go into a urban area and say, we have a school system that it may be better than it used to be in terms of the balance of minority students and that type of thing, but maybe it could be better, and maybe we have resource allocation issues and things like that. There's a whole host of issues that people can still fight for, but I think the principle of Brown is pretty well, I think, embedded in the law. I would be surprised to see the court at least, back away from something like that overtly.
At Amy Coney Barrett's confirmation hearing, she referred to Brown as a super precedent. I never heard that phrase. What in the world does that mean?
Yeah, I hadn't really either. And it doesn't have any real legal significance. I think what she meant was there are certain decisions that are so embedded in our law and our constitutional history that the court would never overrule. And Brown is probably a good one, to pick as an example of that. The question is, what is not a super precedent? She did not say that Roe v. Wade was a super precedent, notably, okay? And of course, now that we have a court that's more conservative, the question is where we're eventually going to go on some of these abortion rights issues, and we don't know that yet. Now, you've heard me say this before, when you talk about precedents, the court likes to talk about what they call the principle of stare decisis, right? Which essentially means you stand by the settled decisions. You don't depart from them. Well, there's exceptions to everything, of course, right? And they do overrule decisions. They do it fairly frequently. The question is not whether the court can overrule a decision. It can do whatever it wants. The question is, if it overrules a decision, does it have a principled reason for doing so? Does it articulate a rational reason that, and the example I like to give is, one of them is Brown, that in the 60 years between Plessy and Brown, a lot changed in the country. The country changed a lot in its thinking, a lot of these issues. It became more clear that it was hard to defend segregated public schools under the Equal Protection Clause, right? So they changed. That's a good example of why I think it makes sense to overrule a prior decision. When they had a similar case back in 1992 when they decided to stick with Roe v. Wade, okay? That decision was the Casey case, right? And the court was kind of divided. And there were justices that wanted to overrule Roe v. Wade and still do, but they didn't, okay? And the opinion laid out a strong case that in order to overrule a prior decision, there should be sound reasons to do so. Things like changes in circumstances or whatever that justify it. Something other than just the fact that that we have a different court now and that the newer justices on the court have a different view of things. Because if all they do is change their opinion as new justices come on, what's left of stability in the law? People like to think that when the Supreme Court issues a major decision, that decision will stand unless there's some good reason to depart from it. So I think getting back to Roe v. Wade, in my mind, I don't see sound reasons to depart from Roe, regardless of what position you take on abortion, because the country hasn't changed on abortion, right? If you read the polls,
right,
something like over 70% of the country supports Roe v. Wade. You know who doesn't support it is some of the justices on the Supreme Court who have never liked it to begin with, and maybe some of the newer justices. And we have a relatively minority fundamentalist religious faction in the country that, of course, doesn't like Roe v. Wade, but that's a minority of the country. So the question is, what is the principled reason to overrule a decision like Roe v. Wade? I haven't heard one, but they do what they want.
Thank you. Well, I thanks to Jack for demystifying what is often a very mysterious workings of the United States Supreme Court. That's all we have for today, and we will hope to see you again.
I would like to extend our heartfelt thanks to Martha Grace and to Jack Ross once again for generously sharing your time and expertise with us today. Thank you both for helping to illuminate the historical and legal significance of these 4 landmark decisions of the Supreme Court, and to understand how they continue to affect the application of the law. The Worcester Senior Center and the Worcester JCC have a long history of collaboration. I would like to thank Lapin for being a program planner and partner extraordinaire, as well as a trusted colleague and dear friend.
Thank you, Nancy, Martha, and Jack. All right, everybody, stay safe, stay hydrated, and stay connected by watching the government station channel 192.